This account was created to provide information on how current immigration laws apply to certain factual scenarios. There are many, I suspect, who are worried about their immigration situation, but they're not sure if they should speak to an immigration attorney. Keep in mind, and I cannot stress this enough, that immigration law is unbelievably fact-specific. So even if you think that your situation is nearly identical to one of the ones that I go over here, you still need to speak to an immigration attorney personally. Even the smallest factual changes can make a big difference in the outcome. That said, this is not legal advice. I'm hoping this will merely help educate people as to how the immigration laws work, because I know there are a lot of anxiety exists in certain immigrant communities. Also, immigration laws and procedures will likely change quite a bit in the months to come. So what might be accurate and current at the time of this recording very well could change in the weeks to come, maybe even tomorrow. Okay, so this individual entered the United States on a K-1 fiancé visa in 1998, but she did not marry the petitioner. In 2000, her employer filed a labor certification, which was later approved. She is now married to a U.S. citizen, not the one that petitioned for her for the K-1, and she wants to legalize her status. All right, so yes, she has a 245I labor certification that would normally make her 245I eligible because it was filed in 2000. The issue here is that she entered on a K-1 visa, and when you enter on a K-1 visa, the laws basically say that the only way that you can adjust your status to being a green card holder is by marrying the person that filed the fiancé visa petition for you within 90 days and pursuing the green card that way. Even though she entered legally, and 245I is generally meant to help people that entered illegally, even though she entered legally, she's still not 245I eligible. Okay, so the K-1 visa entry is one of the more specific and nuanced things in immigration law. So had she actually gotten married to the individual within the 90 days, there might be more to look at here on whether she could adjust her status potentially. But the fact that she entered on the K-1 visa, then never married the person that petitioned for her and stayed illegally for years, the 245I won't actually cure that. It's not something that comes up too often, but I have seen it a few times in the last few years. And initially, I was surprised that we weren't able to cure it with 245I, as was the client. But the law on this is pretty clear that you can't adjust status with 245I if you have a K-1 visa entry and you didn't fulfill the marriage that it was based on. So hopefully that helps. And if you have questions about 245I or any type of marriage-based case, feel free to reach out to us. We're happy to help. Thanks.